We've saved the best for last.
The best for last.
The best for last, professional responsibility. And
Right.
here on our panel are John Snyder. He's an NYU alum. He is a principal in the New York City office of Jackson Lewis with extensive experience litigating state and federal discrimination, retaliation, commission, and wage and hour matters, among others. And I think I forgot to say this.
Folks,
Really robust bios are in your materials. Please read them. And of course, the man who needs no introduction, esteemed law professor.
Thank you very much, Davida.
At NYU and the director of NYU's Labor and Employment Center, Professor Samuel Estreicher.
Thank you. Thank you for staying. I know this is the last hour or part of an hour, and really appreciate it. I thank John Snyder and Davida Perry for being here. This is a call to action. I did a conference in 2015 called Beyond Elite Law. We are basically all engaged in elite law, including Adam Klein. We are all engaged in elite law, whether we're academics or CLE, whatever we're doing, clinics, we are basically engaged in elite law. There's nothing wrong with that. There are a lot of positive benefits from it. The problem is most American people don't have quality legal assistance. And by the way, they have no bar to help them. How do I know this? I'm an employment lawyer. I do a lot of pro bono on my own with individuals. There is no bar in the employment area. I would argue there's also no, if you're making under $85,000 a year and you don't have a sexy case that will attract an Adam Klein, there is no bar. There's no bar. There's no bar in the immigration area if you are seeking to facilitate a green card. There is a bar, happily, for people unlawfully in this country to facilitate their asylum claims. That is true. There's no bar for most people to deal with a will. The people they encounter in private practice are absolutely incompetent. I mean, I know this from my own personal experience. We had no money. The person we had to deal with our injury claims, I mean, I'm embarrassed to tell you the person passed the bar. So when I say this is a call to action, there is no one way to do this. I'm a Catholic, lowercase c. I'm inclusive. That's the original meaning of the word Catholic. There are many organizations out there, and I want to say a few words about them. They all do good things. They all do good things, but we need to do more. What I'm proposing is not a solution. It's just, I think, an important addition. And then we need to sort of take, my basic idea is to take pro bono in a different direction where it becomes an obligation of every member of the legal organization, not just law firms, corporations, nonprofits. It becomes an obligation of every lawyer in these organizations to commit 50 hours a week, 50 hours a year, I'm sorry. I killed my own proposal there. 50 hours a year for non-transom work. I'm sorry, for cause work. I'm screwing up my metaphors. For work that comes over the transom, not work that you are interested in. We know we have lawyers for work you are interested in, or work that titillates your political fancies. We know you can get that. But these are people with everyday prosaic claims, and they need help from competent people. That's what I'm talking about by over the transom. That used to be the model of the clinics. It's not any longer the model of the clinics. I'm basing my experience on NYU School of Law. This is where I've been most of my life, since 1979. It started out that way. It started out that way at Harvard. They've moved in a different direction. They do good stuff. I take nothing away from them. So we have great laws in this country, terrific laws. And actually, the Europeans, and if they looked carefully at our laws, and I think you heard it a little bit from my former student, Daniel Hund, I don't know if he's still in the room. Great, we have actually better laws than Europe, even after Trump, better laws than Europe, certainly on the employment side and the employment discrimination side. They have labor courts, which is a kind of user-friendly dispute resolution mechanism in many of these courts, which has a lot to be said for it. But you heard from Daniel Hund earlier today that they're limited as well. Talking about Europe, I was just using that as a counter example. Many sources of assistance in this country, but they're all limited. Unions do great things. They also do bad things, but they largely do very good things. But unions are there for a very particular role. They're not there as general legal service providers. Many of them are not lawyers, by the way, or do not want to take on the obligations of lawyers and what they do. Publicly funded legal aid, terrific. I applaud it. They all have income limits in whom they can serve, and they also have very large queues. But they do very good stuff. Take nothing away from them. If you take they're basically only going to take people who are 200% or less of the poverty line, which comes down to about $30,000 per year for an individual, or $62,000 for a family of four. I mean, that's the limit, and of course there's a queue even if you come within that eligibility. But if you're making, I don't know, $75,000, $80,000 a year, you're basically out of publicly funded legal aid, even if you have a case that attracts them. EOC, I love the EOC. 88,000 charges a year that they basically don't handle. They're on the dockets, and now they've got mediation, which I favor, by the way, so they've cleared some of that, but basically they don't want to take those cases. You know why? They're not interesting cases. They're who did what, whom, when, and where, and how. What happens to those cases? Well, over time, they languish there for a long time, and at some point the EOC issues a right to sue letter, and then it's a disaster, because then you have 90 days to file a suit. And so, you know, even Clarence was criticized for this back when he was EOC chair, keeping these charges keeping these charges in the system because you don't want to issue a right to sue letter. Now, I think some of the state and local agencies are a little different here, but they're basically not doing retail law. And I don't blame them. If I'm in an agency, I want to make a name for myself, I'm going to do the kind of stuff that will attract attention in general. And by the way, it's all good stuff. It's all good stuff, generally speaking. Cause lawyering is very useful, but we're not dealing with the everyday needs of American people. That's my point. Plaintiff law firms do great things, but again, you know, they have to make a living. You heard that today, and it makes sense. You know, class actions are useful, but I would argue very often they do not provide retail justice for the claimants. They do a lot of good things. You got lots of people in that class. You divide it up by the amount of the settlement, by the number of people. I did a whole paper on median settlement values for individuals in publicly disclosed Title VII class action. It's very important. Provides deterrence and all that stuff. And we should do it. But essentially, if you have a claim under $70,000 and it's not sexy for litigation, I mean, if I'm running a private law firm, I'm going to be very reluctant to take those cases because I'll bankrupt my firm. I need to take care of my associates. I don't do it. Law school clinics. There's been a change. Take a look at my book. It's called Beyond Elite Law, 2015. I have 2 chapters there by the head of the Harvard Clinic way back in the old days, what they were. They were, in fact, a neighborhood law firm. Not anymore. Then none of them are doing it. We are helping in our clinics, in all kinds of clinics. We are in international cases. Everyone wants to be a George Clooney's mate. They're all doing the same work that she does. Briefs in the International Criminal Court. Let's have 200 more briefs on the International Criminal Court. I know I'm overstating it, but you know, there are people in this country that are not getting legal services, and we've been trained for it, and we're not doing it. So it's a default in my view. Law firm pro bono, good stuff, and I'll talk some more about it. But by and large, law firm pro bono, with some exceptions. I've been at 10 major firms. Now, everyone tells me, I met with Betsy Plevin 10 years ago when she was chair of the, she said, not at Proskauer. Who was she kidding? I mean, I know all the lawyers at Proskauer, what they do. That's what she said to me. I didn't want to have an argument with her. Only 2 people get involved in law firm pro bono, in general. Some firms are a little different. Schulte Roth advised nonprofits on their handbooks, so there was more involvement. But no one wants to burn their career at a law firm doing pro bono unless they want to get out of that law firm. So essentially what's going on for the public relations value of the pro bono, which is very important, these folks basically are assisting major NGOs en route out of the firm. That's the reality. Most people don't get involved in law firm pro bono. I don't have data on this, but it's based on 10 different law firms, major national law firms, all with pro bono programs. So what am I proposing? I think it needs to be tailored to what I've identified as a need. The need is for people of moderate means to deal with their prosaic, uninteresting legal matters. You know, doctors do this all the time. I go to a doctor with a problem with an infection in my nail. They're not going to get the work publicized by the New England Journal of Medicine. It's just not interesting stuff. No one's going to publish it. But it's just part of their service. Now, they get paid. That's true. There's a problem in medical services and paying for it and who gets medical services and all that. But they're doing prosaic stuff. We want to do elite stuff, core stuff, stuff that has an impact. And it's all good, but that's what we do. And so what I'm suggesting is something that supplements all these other things, doesn't displace any of them, supplements all these other things. I call it storefront pro bono. The storefront, I borrowed this from someone else who gives me permission to use the term. I want him to enter into a formal joint trademark agreement with me. It hasn't happened yet. He uses the phrase for a very different kind of pro bono program that he has, where he basically is trying to gin up class action business for himself in Texas, and he uses that for him. So I said, please let me use the phrase, because I think it's cool. And we haven't worked out the trademark yet, but I still have his permission. Until he revokes it, I have his permission. The idea is to have a modest law firm commitment to pro bono, 50 hours a year from each lawyer. Whether you're a transactional lawyer, a litigation lawyer, it doesn't matter. Whether you work for the government, it doesn't matter. Or a nonprofit organization. 50 hours. Now, the ABA says that is your requirement, but that's just a hortatory. It's not an actual obligation that'll get you disciplined, but that is the requirement. It's not a lot. It's not a big commitment. And the idea is the law firm, or whichever organization is sponsoring this pro bono program, we will basically, it could be just a metaphor, the storefront. We don't necessarily have to have a place. It can all be done through the internet. It doesn't have to be a place. Obviously, if it's a place, that'd be nice because people can show up there. We advertise it widely, and we take all comers. That's the idea. Now, of course, if they're making a certain, we could implement this a certain way. If they're making a certain amount of money, we don't take the case. We send it off to our plaintiff firms on the Labor Center, like DeVita, who are really extremely competent. If the case involves litigation, we don't take it either, because litigation is a major expenditure of time and resources, and that's not what I'm talking about. If we might help vet the case for the lawyers and say, do you think there's an issue here? But we are not taking litigation. That's not part of this program. We have organizations out there that will. We may actually identify that there's something serious about the case. Most cases don't go to litigation. I'm employment law focused, even though I teach foreign relations law and legislation, administrative law. Employment and labor law has been my life since the very beginning. Don't ask me why. It's been my life since the beginning. I went to the Cornell ILR school, as you heard, even before law school. In employment law, litigation is the worst thing you can do. Why? Certainly if you're still an employee, that's the absolute worst thing you can do. And even if you're no longer an employee, suing the employer is a very big Herculean task. And by the way, it's going to blackball you in the industry. I know it's against the law, by the way. It's retaliation. And we'll get Adam Klein to pick some of these cases. But that's what's going to happen. You sued this company, your former employer. I'm not going to touch you. I'll even beg the employer, please give him a chance. No, we're not going to hire this person. So it's a suicide kill in that respect. In employment, I'm thinking of starting this idea in employment. The idea is we put together people, we try to encourage the law firms and other organizations. I'm going to have a meeting with the Chief Judge of New York Court of Appeals. I want to try to sell this in a way that will get buy-in from law firms. I think this would be all lawyers. It would not involve litigation. It could be transactional lawyers. I mean, really, my son is a fantastic representative of banks and other lenders in complex real estate deals. It would not kill him to do a routine closing. It wouldn't kill him. Or to help draft a will. I mean, it's not that small, not that hard. I didn't take trust in estates because I was a semi-radical at Columbia Law School. So I didn't take any of these courses I should have taken, which is true of my students here as well, by the way. But, I think I now can draft a will because I've had wills done for me and I've criticized the lawyers for what they do. I don't think it's that hard. I don't have that, most people don't have a complicated estate. Also closings, you got to be kidding, brain dead work. Why do you have to pay lawyers for this? I mean, why don't you learn how to do it as part of your toolkit? Right now, you're going to be working, these associates are going to work at these law firms, they're going to be paid $225,000 for doing brain-dead work. I'm basing this on my experience. It's called leverage. We litigators, you get John and I involved, we get us later in the case, we'll get the case settled on the right terms. But we got to create some leverage. So these people don't get any skills. You throw them out in 2.5 years, they've got nowhere to go. They can't do anything. They don't know anything. So they're going to fall back on their NYU laurel, their Harvard Law School laurels, but they can't do a damn thing. So what I'm suggesting is a program that actually provides not only benefits for civil justice. I think there's a better shot at criminal justice, but I'm thinking of civil cases, civil justice, enlarging access to civil justice. Now, people tell me you can't pro bono your way out of this problem. I agree, but it can make a major dent, I believe. It provides benefits for the participating lawyers. For these guys that are making $240, I'm not feeling sorry for them. These guys and gals making, or the theys in the world, my granddaughter is a they, guys, gals, and theys in the world, give them some skills. They'll feel better about what they've done. And not only that, they'll have more portable value. I tell my students, develop portable value. That is the only way to be loved. Develop portable value. So develop some skills here. It can actually enhance the skill set of these participating lawyers. Is it going to turn them into John Snyders of the world? No. But it'll give them a sense they actually can interview people that are not super educated and get the facts. But even professional lawyers have trouble doing this. I'm doing a malpractice case. I don't want to tell you which company is involved, but I can't believe that how poor the lawyering was. Even professional lawyers from major firms, the senior associates don't know how to do an effective deposition. It goes back to my first deposition. I'm going through their employment search. Why? Because I'm scared, and because at Columbia Law School they didn't teach me how to do a deposition. And so I'm wasting a whole day of deposition. This is before they put stark limits on it. A whole day of deposition on stuff that's totally useless. I cannot use it. Because they'll say they sent out a resume to 200 places. Who's going to deny that? So I think it helps build up the skill set of the participating lawyers. And it's a training, it has a training benefit for the firm and a morale benefit. We care about the culture. We want a culture of public involvement. This is a way to do a culture of public involvement. It does not require burning the career of the participating lawyers. That's the key. It doesn't require burning. And I think it should involve not just advice, not just referrals to other lawyers like Davida. That's a very good referral. But also talking to the client, getting the facts, going through the documents. They're getting all this stuff on releases and stuff. Now, that doesn't mean you can challenge all of it, but some of the stuff is problematic. You know, they want you to release all. What's the word? They want you not to disparage, non-disparagement clause. They don't want you to disparage existing employees you've dealt with. What I say is, I love it. Let's make it mutual. Can't we teach these participating lawyers to do the same thing? And now they'll have a better situation. Or if it's a restrictive covenant, have a conversation with the employer decision maker. Hey, are you aware of what's going on in New York law and restrictive covenants? It's problematic. So I'm not talking about litigation, but sort of informed, non-litigation representation. I believe this is good for the participating lawyers. They will be better, more likely to be effective partners for the firm down the road, I believe. Now, the people in the NRE get a lot of this, so this benefits training isn't that useful, but, you know, it might be. It might be, because you may be used to taking affidavits for 10 Js. Well, how about an adversary proceeding a little bit? You might have to do it. So I think there are benefits for the participating lawyers. And I think there are benefits for the law firms as well. Now, the law firms do a lot of pro bono stuff. Mike Gray's not here. He tells me he's got 2 law firms in southern Texas dealing with the immigrant cases. I understand that. But he can also do this, I believe. Now, the people that are involved in those Texas law firms, the law offices, they will satisfy the 50-hour requirement, so it doesn't affect them, but everyone else. So I want to sell this to the judges first, and then I want to sell this to law firms. I may not be able to sell it to all law firms. It's not for every law firm. Let me deal with a couple of costs, and John Snyder's got some great questions for me. I have responding to some of them. First of all, we did a piece. I did a piece with Samuel Ball, my associate. We published it in the New York Law Journal. They screwed up the heading, so I had to republish it in another journal. The heading was something like "Modest Proposal for law firm representation. And I said, why didn't you clear the heading with me? Because nobody wants to do anything modest. It's a modest law firm commitment. They left that out. So I had to change it. I got Law 360 to change it, but it's sort of, it killed the circulation of this piece. But we also did a piece on positional conflicts. So one problem is positional conflicts. Now, I just don't believe, and I'm dealing with employment. It's obvious, if you're an employment lawyer and you don't want to get involved on employment matters here, there are other matters we can do. But I don't think just because you're a management lawyer, I was a management lawyer, I was of counsel all these firms, I still did a lot of pro bono representation of people because I'm not signing away my soul just because I'm a management lawyer. The ABA doesn't require that. The model code doesn't require that. They want you to avoid conflicts which are likely to arise in a litigation context. In other words, if I'm representing a pro bono client or someone else, and I'm going to create precedent, the word precedent appears in all of these. Take a look at our article. That did appear in the New York Law Journal with the right title, and it's in your materials. You shouldn't be in a situation where you're doing something, whether it's pro bono or paid, that creates a precedent that harms other clients of yours. There's no question about it. No question about it. It's just not likely to happen because these are not litigation matters. If you think litigation is warranted, I've got 15, 18 high-quality plaintiff lawyers on my board that'll take the case. And they'll thank you for vetting it for them. We don't have to do that. We're not going to do that. We're not going to do litigation. If you want to do litigation, you can get the permission of your law firm or get some malpractice insurance to do the litigation. You know, I have nothing against that. I'm just saying that's not what this commitment is. This commitment is to be an advisor, not just a referral, an advisor reviewing documents, and if necessary, having a non-adversarial meeting with the corporate decision maker. Now, I'm trying to sell this to my clinics here, and they say, this is not a clinic, because this doesn't go all the way. It's not a clinic, and they won't help me out because it's not a clinic. I don't know what they're talking about. I ran a Supreme Court clinic. We didn't go all the way. All the way is nonsense. We want to resolve these conflicts. So I got the student that I thought was really good, and we produced the papers as best as we can. We don't want to go all the way. Why are these clinics going all the way? I don't think they're going all the way either, but that's what they say. I'm not going all the way. So for that reason, they will not even shelter me within the tentacles of a clinic here. I just don't understand it. That's so far away removed from the original model of law school clinical education. It's just hard to believe. It's become cause lawyering through another form. And on top, the clinics are also very inefficient. The rule of thumb out there, the rule of custom, they only do 8 students per instructor. So not only are they not necessarily picking the right cases, they're largely focusing on impact cases, but they can only do 8 students per instructor. I don't know why. I mean, we teach students, 150 students on substantive law, right? We can teach 30 students on what the rudiments are necessary for being an effective representative here. Okay, so that's one cost, right? Positional conflicts. So my view is, if you're a lawyer and you're in this storefront pro bono operation, and you want to build business with the Hearst Corporation, I think there's someone here from the Hearst Corporation, maybe you're wrong. You don't have them as a client yet, but you want to build up a practice. So I'm not going to go into print media. Fine. If it's print media, don't get involved. Okay? Don't get involved. No one's making you do it. On the other hand, what about this case involving construction industry? Do you have your sights on construction industry clients? It's a very specialized practice. I don't know. You might. So I think a lot of this is in the control of the participating lawyers. I'm referring to employment now because I want management lawyers involved, not just plaintiff lawyers in the pro bono clinic. Because they have some knowledge here and, you know, not having them involved, I think, skews the program from my standpoint. But there are other areas where we don't have this problem. So, for example, I believe, notwithstanding who the speaker was here last week, there's a serious problem in helping people getting green cards. Very serious problem. Whatever he said about border security, everything he said was right. My answer is, so what? We still have this problem. People are working here, getting green cards, pushing the administrative agency. That is a great skill to endow young lawyers with. That's what we do. I'm working for you. I'm not young enough to work for you anymore. I wish I had been. Well, we push agencies, recalcitrant agencies, to do good things for us and for our clients. Sometimes we do that by befriending them. We try to get them to see the world our way. I'd love to give you all this information you want. I really would. We may do it down the road, but let me first tell you about the case. Right? Because you try to avoid the disclosure. Anyway, so that's one issue. Another issue is reputational conflict as opposed to positional conflict. I want to be a management lawyer. I don't want any possible client in the goddamn country, maybe the world, because we're global now, thinking that I ever represented an employee. I don't know what weight to put on this reputational conflict issue. I just don't believe it. I think if someone is in this program and does a really good job getting a decent settlement from the Hearst Corporation, and now he wants to go to work for Jackson Lewis, I'm interested. He seems to be an effective lawyer. Rather than hire these kids out of NYU Law School for brain-dead work, you got to give them some quality-adding work, value-adding work. I just don't see it, the reputational cost, but maybe I'm wrong about it. Malpractice could be a problem. I don't know. Right now, I need malpractice. And I've tried to get it from the clinics, under the mantle of the clinics. I'm trying to get it from the dean. It's being slow-walked by the dean and the university. I don't know why it's such a hard thing. If I'm running this thing, I've got members of my Labor Center board that actually want to be involved with me on this, but I don't want to be sued. I don't think any suit would be meritorious. But the great thing about this country, you bring lawsuits and they're not meritorious, and you don't get thrown out. And that causes, that's like a hell for you. Forget about the out-of-pocket cost. It's hell for you. So I want malpractice insurance. I can't get it. So malpractice is an issue. Now, is there a malpractice issue? I don't know. I need to know what the law firm policies are here or the other organizational policies. I'm not ordinarily a property lawyer, but I'm going to learn enough skills to do a routine closing. Is the law firm's malpractice carrier not going to cover me? I need to know the answer to that. I don't know why they wouldn't cover me. Maybe there are certain restrictions like that. I just can't understand that. Non-litigation work, but that is an issue. Vetting is an issue. We don't want crackpots involved, so we need to hire someone to vet the people that come over the transfer, make sure that they're coherent. You can talk to them, and they're not going to be bugging you for the rest of your life, and that's important. So vetting is important, and the training of the people involved. So if we see a property matter or an immigration matter, this can be trained, and we bring in some of our senior people, our professors here at the NYU Law School, to train them on the substantive law they need, if they need it. Most cases don't need a lot of substantive law. I mean, I do this, by the way, on top of my 19 other things that I do. It doesn't need a lot of substantive law. Because I'm an employment lawyer, I basically know. Let me see your performance evaluations. I don't have them. Well, let me see your bonus history. I don't have them. Well, you know what I say? Sei gesund, which in Yiddish means get lost. That's not actually the literal translation, but he's got nothing for me. I'm not going to waste time unless he's going to pay me the usual 1,000 an hour I claim, or 800 an hour I claim. Okay, John, your turn.
Well, thanks for having me. Our firm, and I think one of the reasons Sam asked me to be here is I coordinate the pro bono function for the New York City office. And we do some of the materials you prepared talk about Lawyers Alliance for New York, and we work with Lawyers Alliance, and one of the comments in the materials is that Lawyers Alliance gets to the NGO, the nonprofit, but doesn't get to the transit, doesn't get to the individuals in need. And I think your thought leadership here is timely. There was an article recently in the New York Times Magazine called Lawyer Up, Increasingly Americans Can't or Won't. And it was kind of a heartbreaking article.
New York Times Magazine?
Yep.
Okay, thank you.
It was in April. And he talked about people dealing with real issues, child custody, protective orders, and they were just tripping through the proceedings. They couldn't get in evidence. They came with computers and videos and audio. And one of the commentators said it's like playing chess without knowing the rules. So, clearly the issue, I think, is timely, and there is a need. And a couple of things that resonated with me a little bit is, I remember when I was in law school, one of the professors here quoted President Jimmy Carter and said that 90% of the lawyers represent about 10% of the folks, and that we're over-lawyered and underrepresented. And so there are folks that, and I think Sam's papers do a great job of talking about income requirements, and particularly in a city like New York, $70,000 gets you nowhere after taxes and basic necessities, and the average legal fee is about, $370 an hour, and I thought that was low. I think it's a statewide average
Right.
when you look at his materials. So the need, I think, is obvious and it's grave. Some of and I was happy to participate, but some of the issues that frankly I'd like to vet are the practicalities.
Right.
And DeVita's right here, but I'd love for them to start with the plaintiff firm first, because this way, if they do the advice and counsel and there's litigation, you can take it. I think practically speaking, I just think about how it might work. So if everyone knows that Jackson Lewis is a management side firm, and I'm speaking on behalf of myself and not the firm, and I'm part of this storefront pro bono, and they know that I'm not going to litigate on behalf of an individual, how helpful am I? After the first 2 or 3 times, if you're having me engage with a governmental agency or an employer, they probably tell me to go whistle up a rope. They know that I'm not going to take it the distance. So I think that is a concern. I also think, and I know you touched on it, and it's kind of dense in the material for late in the day, but the issue relating to positional conflicts. And I think those of us that practice on a day-to-day basis, there are positional conflicts and what Sam referred to as reputational conflicts, which I kind of refer to as practical conflicts. It's very hard to get clients. Sometimes it's harder to keep clients. The competition is immense, and I don't know I do a lot of work in the real estate space, what some of my clients would think about if I kind of coached, except in very, very generic terms, an individual. I might tell them to look for something that they might not otherwise have thought to look for. So, one of the things with your proposal is there any room to generically answer questions or respond to a hotline, tell people where to look, maybe connect them with DeVita, connect them to websites, if there are forms for requesting leave. But the minute, I'm giving advice to an individual and I work in a management side labor and employment law firm, I get concerned. And even if you're right, and there's a way kind of to be able to cut through the thicket, those of us that work at large law firms, it takes an enormous amount of time. I mean, just conflict checks sometimes when you go through the parent affiliate subsidiary tree can take a long period of time. So I want to help. I have a demonstrated interest in pro bono.
You do.
I like helping organizations and I like seeing it, impact the individuals. But, that is one area where
The employment area.
the employment area, I mean, I almost wonder if I'd be better off, helping with the small consumer issue or helping with the housing issue.
Right.
And I think, that gets to the second place that you were talking about, which is, the malpractice and how to deal with that. The other thing relating to the malpractice is, depending upon the firms that are here, some firms don't have malpractice. There's no per se requirement to have malpractice insurance in New York, or they could have very high self-insured retention.
Right.
So to get folks involved, I think the malpractice is a significant issue that would need to be worked out. But I wonder, one thing that occurred to me is, you said you wanted to start with management side, labor and employment law firms.
No, it's employment law.
Just employment law. So it could be, you could start with
I could start-
corporations
Yes,
or
yes,
government
yes,
lawyers.
yes. I'm only doing employment because I know it, okay, and I know there's a need. And most of the stuff is not litigation. Now, it is true that with some employers, you're not going to make any headway if you're not a litigation threat. On the other hand, I have made headway and I'm not a litigation threat. And the alternative is worse. But no reason why it couldn't be a more minimal participation by some of the lawyers, like the hotline.
Okay.
I'm not a true believer in that sense. I think this is something that would add significantly, improve the problem, even though it's not perfect. There's no perfect solution here, by the way. But I think it will improve the problem, and I think it will also, I personally believe, based on talking to a lot of associates that I've dealt with, it would make them more valuable associates, in my view, and happier associates, because they basically engage in a devil's bargain, where they're gonna get, and again, I'm feeling sorry for them, $200,000 a year, and they're not adding value. But by the way, AI is coming, and that leverage stuff is gonna be gone. The brain-dead leverage stuff is gonna be gone.
I mean, that part,
And so,
I
yeah.
read your materials, and that part I agree with. The client intake, trying to figure out what's important versus what isn't.
Right.
The soft skills, as you refer to them, those are great skills for a young lawyer. Particularly, corporate clients don't want to pay for someone to kind of learn that and
Right.
ask too many questions and look at too many documents and all the efficiencies that could be associated with that.
Right.
I guess another thing that occurred to me in looking at your materials is whether there's any intention to lobby either the courts or the bar associations, because I think firms tend to be conservative about these issues. And if there were clarity, I mean, I saw the analysis on the New York rules and the ABA, rules relating to positional conflicts, and I follow your analysis that it seems heavily geared towards litigation, but there are references to advocacy.
Yes.
And I think if there were enhanced clarity on those issues, that maybe more firms would be willing to.
Totally in agreement with you, John, and hope we can work together on this. My next stop is the Chief Judge. I would have gone to Chief Judge Lipman, because in my 2115 conference, he was a major supporter of the conference and the idea. He's been very busy on other matters, but the current Chief Judge is a friend of ours, and maybe we can go together and talk to him about it. Okay, John? If you don't mind. And some other people as well. But I mean, I need to get more active on this concept. I think there's interest, right? And it's got a lot of details. And the only reason I'm starting with employment is I know it. That's the only reason I'm starting with it. No reason it has to be employment. It could be other things as well. And that would make you more comfortable, right? It would make the management lawyers more comfortable.
Well, it would make me more comfortable substantively. I'm not sure it would make me more comfortable until I got clarity on the conflicts issue.
Right,
So, in some ways,
Okay,
right,
so
we
that
only
comes first.
do.
Let's do conflicts
Yeah.
then. We're gonna do conflicts together. It'd be great to have that. One problem with these professional responsibility opinions are very generally written, but we're gonna work on that together. Thank you very much. Anything else, folks? Comments? Questions? Those of you who represent corporations or in-house organizations? I'm sorry, please, identify yourself, please.
Love the idea. I think you're gonna have a really difficult time with the big firms. When I was at Legal Momentum and we were doing employment cases, impact, and we needed co-counsel, the defense firm said just the subject was a conflict.
I understand.
And they had a bright line, and that was it. I later worked at Disability Rights Advocates where we were doing Title II of the ADA, so it was about access, and we had no problem. But I
understand.
think they need cover. They need this to be mandated, and if they had some cover, this conflict wouldn't be as much of an issue.
We need clear guidance here from the courts and maybe the professional bodies, absolutely. I agree with you completely on that. That's one reason why we have some of the law firms suing public sector employers, because they don't see a conflict. Even though there may be precedents set, actually might create positional conflicts, because they're bringing disparate impact cases. But I think Jones Day was more comfortable doing that. Other comments? Mark Risk.
I represent individuals, although for these purposes, I'd say I represent individuals mostly. And I wanted to just comment, when we hang out with our European colleagues, it's very refreshing because the firms over there represent both sides. Now, they're executive employees, but very common to see a firm that's representing individuals and employers. But the thing I wanted to add to the mix is, I work in a bar in which A lot of my plaintiffs' colleagues have a hard rule that they only represent employees. And of course, our management friends have a very hard rule that they only represent employers. And I am certain that representing both sides, talking to both sides, makes us better lawyers. I'm just certain of it. Because you know, we are what we eat. And if all you do is think about how to defend the claim, or all you do is think about how to prosecute the claim, you don't see the whole claim.
Thank you, Mark. Other comments? Sir, would you identify yourself? See, we are a global law school, intergalactic even, but our microphone system seems problematic. Go ahead.
Sam
Name?
Rubenstein.
Yes.
What are your thoughts on like a low bono model where firms may be charging a reduced rate, and then specifically in the employment context of like reviewing separation agreements or settlement agreements, like very like specific concrete tasks where, you know, I'm just curious, like thoughts about that.
Mine or DeVita's? I mean, I think if it makes sense economically for the plaintiff firms, they will do it. I mean, I don't know to what extent they can sort of separate it out from the possibility of other more extensive involvement, but I'm not against that. I mean, it's, again, I'm Catholic. Adding all these things, yes, I mean, if there are legal restrictions or professional responsibility restrictions on doing that, we should take a look at that.
Are you suggesting there be an income threshold? Because, I mean, one of the things that struck me about Sam's materials are the need in terms of the poverty line and how some of these publicly funded legal services corporations, you know, they're very closely tied to the poverty line,
Yes, they are.
but practically speaking, people can't live anywhere near the poverty line. So, I mean, it's interesting. One of the things I thought about was, you know, lower rate work and how to kind of expand accessibility. But in a city like New York, it's very difficult because what you make here doesn't go very far.
Yeah, I'm aware of just one nonprofit. I think it's in Virginia that sits down with employees and like charges them a flat rate to review like a separation agreement. And I forget what that flat rate is, but it was an interesting model that I've never considered before because it always felt like pro bono or bust.
And there's something called the DC law firm that does something like that. I don't know if it's low bono, but they charge. I'm all for it.
Thank you.
I'm all for it.
You should get in on that name too.
Which one?
Storefront pro bono and low bono.
Low bono. Nobody wants to be low. You know, so we have to take out some other nomenclature. Other comments or questions on this side?
You get somebody like that.
Where?
Purple.
Straight back there.
Purple person.
Purple shirt.
Identify yourself and your affiliation.
Jeff Rogoff, Department of Labor, again, only speaking on my personal
course.
capacity. You know, I've had a number of conversations with some of my federal employees who are about my age recently in terms of voluntary early retirement. And one of the things we talked about was, okay, it'd be nice to be in a position to do pro bono and, you know, and devote a certain amount of time to that. And then we were thinking about some of the things that would make that hard. And there were a number of the things you were talking about, like, would we be able to get insurance for the activities that we're doing? Would there be some kind of support for us? You know, even though we recognize there's a tremendous need, we don't want to go in and do something incompetently.
Right.
And so, like, the support network that you're envisioning, like with law students or it seems to me that there's a number of retirees who would really like to be in this position, but if there was a system in place that could provide support for them as well, and insurance, I think you'd be able to tap into a good network of people who could give a lot of quality aid.
It's a great suggestion. Some of the bar associations are doing this. Take a look at my 2015 book. We have a whole chapter on getting retired lawyers involved. And I think it could be part of this proposal as well. I agree. But you need institutional structure. Other comments, questions? I don't see any, John. Do you? David, do you see any? All right. You have my blessing. You get CLE credit. Go on and do good things. Thank you, John.
Good time to do it.